Thank you, Senior Counsel Zara. May I please, Your Honor, Submission 3. The fact and the incident, the offender is not within this litigation. Offender is essential of the event. My client argued, claim 1. Offender arrived TMG, he consumed alcohol intoxicated before arrived. 2. Applicant and offender confront at the beginning walk into TMG and break up period of a reasonable time. Firstly, my client defense based on the principle inheritance risk is a risk of something occurring that cannot be avoided. The applicant argued can fail to provide a security guard on the Sunday evening. Inheritance risk. Defendant is not liable under Civil Liability Act 2003 Queensland Act Section 16. No liability for materialization of inheritance risk and reasonable foreseeable. My client is not liable, breach of a duty of care, fail provide security guard. The similar cases, Frank Hansen is Parker. Parker against Tall Ships Sailing Cruises Australian Proprietary Limited, 2015 case, Queensland Court of Appeal 108, find Parker request another good people lower voice in the cruise. He was punched in the side of the face behind. The court held defendant, Tall Ships Sailing, did every step as a reasonable for the premises, as safe as a reasonable care. The applicant can dismiss. Second, defense based on principle of causation risk. At common law and statute law, Civil Liability Act, Queensland Act, Section 11, a decision that a breach of duty cause harm compresses the following element, factual, causation, and scope of liability. Two steps must be satisfied. Step 1, has there been a break in the chain of a causation? Applicant and offender confront at the beginning walk into the TMG and break up period of the reasonable time. Offender deliberate conduct assault, deliberate cane hit a victim in the car park. Step 1 failed. On one step, second step will be automatically failed. Similar cases as a TMG is Adi, a palace. As Adi Palace against Mubarak, 2009 case 239 Commonwealth Law Report 420. Find security employee is not available was not necessary condition of shooting. The gunman delivered is shoot person. Submission 4. Applicants claim my crime breach of a duty caused the plaintiff harm and recover damage for personal injury and consequential psychological injury. Applicant must show practical reasonable to believe the incident major cause applicant will suffer psychological damage. In fact, based on my senior counsel and submission 1, 2, 3, and 4, there are sufficient materials, evidence. TMG did provide standard of the care for the premises for the customers. Also, offender arrived TMG, he consumed alcohol intoxicated before arrived. There is not adequate trained, sudden shock. The incident is not contributed applicant psychological injury. Once my client TMG did provide standard call for the customer, claim of psychiatric damage failed as well. Your Honor, there are solid and about case law and statute law support the plaintiff likely to fail. 1. Our client does not own duty to the plaintiff. The event that took place was not reasonable, foreseeable, and predictable. 2. plaintiff are both unreasonable and available on the high side due to lack of a prior incident. There's no need to have a security guard on that particular night. 3, the court must be considered offender deliberate conduct assault, hit applicants at my crime are not reasonable foreseeable. Similar case, Parker against Tall Ship Sailing Cruise Book, Australia Proprietary Limited, 2015 case. Finally, there is not practical, reasonable applicant claims psychological injury damage. Finally, applicant will fail arguing can my client TMG is liable, negligence, duty of care. Thank you.